You're excused. Okay, motion to table,
Motion to table.
seconded by Councilmember Scanlon.
Item number 2, concerns regarding 2868 Main.
Items open.
This item is open, and I see we have Mr. Reese on the line to speak on the Zoom call. Mr. Reese? You're muted.
I am attempting to.
You're good.
You hear me? I think I just unmuted.
Yep, we can hear you.
Okay, fine. Thank you for giving us this opportunity to talk. We've got a situation here where I think we've got a war that we didn't ask for here in Central Park. I want to do a little background on this. If you're not familiar with the Central Park neighborhood in Buffalo, it was laid out in May of 1892 by Louis J. Bennett himself. We feel it's the finest residential area in Erie County or Western New York. About 470 single-family residential units primarily, with deed restrictions which specify single-family residential dwellings. It was designed as, in Bennett's name, an area for first-class residential housing right from the start. We have a coffee table book, which I'm holding up here, which you can get in the Historical Society. It says Central Park, Buffalo, New York, a neighborhood of history and tradition. We love the place. My wife and I have lived here for 43 years. We have aggressively, via housing court and via litigation, attempted to enforce our deed restrictions, keep the area the way it was, and we make sure that people keep their property up here. By the same token, this isn't just an area for snooty rich folk. There are 3 churches, one predominantly Black church and a mosque in this neighborhood. It's a well-integrated community. It's a friendly community. We've got one of the finest pocket parks in the area. That's Burke's Green. Routinely, homeless people utilize that park, and they are welcome there. Okay, this is a nice, friendly neighborhood. There's lots of BLM signs in our neighborhood. We had a property which we referred to as 2866 Main Street, which we had in housing court for years. It was a single-family residential dwelling, essentially, that was on a double lot at the corner of Woodbridge and Main. The building was used for a long time as a residence, and then someone opened an insurance office in the first floor, but it continued to be a residential dwelling, and essentially a residential dwelling. It was abandoned as an insurance office. It appears that some sort of real estate speculator purchased it, and it fell apart. And we made dozens of housing court appearances. I mean, I can't even count how many we made. Eventually, the building was effectively falling apart. There were squatters living in it. And, you know, somehow or other, and it wasn't really clear how this was done. It came into the possession of the land bank. Once it came into the possession of the land bank, the homeowners association, Central Park Homeowners Association, which has been very active through the years, and which has sponsored the litigation and the housing court appearances, et cetera, became aware of this and contacted the land bank. We made sure that the land bank was aware of our deed restrictions, was aware of our concerns. We wanted this parcel developed as 2 single-family residential houses. The deed restrictions were made available to them. They obviously had them because they put it in their purchase offer. And we were trying to get a meeting with them. That activity was like, say, summer and fall of last year. So we're still waiting for a meeting with the land bank. Sometime in May of this year, in the middle of COVID, Joel Jambra himself contacted me and said he's developing a property. He owns it on the corner. And I said, that's nice. When you want to come up with your 2 single-family residential development plans, you come and see us, we'll talk to you. And he said, oh no, it's not going to be single-family residential. He wouldn't tell me what he was trying to put up, but apparently he wants to put up 6 townhouses. We don't think that's a good idea. We think it violates our deed restrictions, et cetera. So anyhow, I contacted the land bank and spoke to the executive director, asked who the FOIL records access officer was. I was told they didn't have one. I informed them that they had to have one because they were a public body. And the response was, well, we're a very small office. To which I pretty much said, thank you very much. We foiled the executive director and Mr. Mahaffey, who is the chairman of the board. We've received the numerous documents in response to the FOIL. My wife actually does the FOIL. There's a reason for that. I litigate. It's easier if she FOILs it, and I'm her attorney. But I want to bring your attention to some documents that were produced with respect to this and things that happened along the way. I hope you have them. There is a resolution which is dated October 11th, 2018. It's from Brendan Mahaffey, and it talks about the National Community Stabilization Trust. And basically it says that the NCST is going to donate these properties. There were two parcels there, 2868 and 2866. And they passed this resolution saying, well, we're going to accept this donation from NCST. Well, I called up NCST and quite frankly, gave them a piece of my mind and said, what are you doing? You've caused some problems here. Now I got somebody who's going to develop property which in a manner inconsistent with nature and character of our area. By the way, the actual purchaser of the property is Nicholas Jambra. It is not Joel Jambra. And he immediately, he's a realtor. He bought it for $150,000 and he immediately made it available for sale at $295,000. So his first act was to attempt to flip the property. Well, we learn now or have learned more about Benlick than anyone ever really wanted to know. Anyhow, I contacted NCST. I spoke to the president, who is a very nice lady, and she said, Mr. Reese, calm down a little bit. I'll explain to you what really happened here because you have the wrong idea. And I did have the wrong idea because it was the idea which I got from the proceedings of Benlick. And if you look at another document, there is a housingwire.com article about NationStar, AKA Mr. Cooper. And basically what this entity is a bad boy mortgage servicer that got in trouble with 3 states and had to put out some money, 17 million to New York State, and donate $5 million worth of property. Apparently this came from NationStar, the bad boys. It didn't come from the NCST. NCST only operates as a broker, as it were, putting people together. So thank you to Julia Gordon, who was the president, and I really appreciate the information she gave us. All right, well, we then looked, you know, so number one, this resolution is like crazy world. Well, we then looked at the rules under which the land bank is supposed to operate. And you have, I hope, a property purchase application from Nicholas Jambra. If you look at the second page of this, you will see that under Benlick's rules, about, well, it's the second paragraph from the bottom on the second page. If a property is vacant and adjoins existing structure, it is, if it was vacant when this property was transferred, the adjacent owner happens to be a Buffalo City Court judge, and on the other side of this property is a Buffalo police captain, is the owner. The applicant must submit a redevelopment plan describing proposed use of land, etc. And it apparently it has to show some sort of fiscal responsibility. If you then flip another couple of pages, we then sought in vain a plan for redevelopment with some indication of fiscal responsibility. And if you look at a page which is titled Description of Applicant's Experience, the last paragraph, apparently signed by Mr. Jambra, says the plan is to purchase the property as an individual and assemble a team of professional, that's his sick, not mine, to create and construct a buildings that is most suitable for this lot with current zoning and existing deed restrictions. Okay, well, the plan is to make a plan. It's an acknowledgement that there was no plan. So first off, they didn't have a plan. Benlick violated its own rules. They sold this property without a plan. But it gets worse because the deed that they deeded out subsequent to this was a warranty deed with no reverter clause in it. Because there's no reverter clause, maybe you could make out that Nicholas Jambra has some sort of contract with Benlick here to come up with a plan in a year. I'm not really sure if you can make that out, but maybe a court would believe that. However, there's no reverter clause in the deed. So if Mr. Jambra sells his property this afternoon to someone who has no notice of this, the property's gone, and that can't be enforced against anybody. So what we have on our hands here is a mess. There are some other minor things here. If you look in their minutes, which you should have available, third page of their meeting. This is Benlick's meeting of December 19th of 2019. The third page is the resolution by which they devolved this property. They basically indicate, and this is the first time we knew about it, they put the two parcels together into one. Well, these are two single-family residential parcels that faced Main Street. Now it's a single parcel. And that is not facilitating development of two residential structures. In fact, what we in the neighborhood would have liked to have seen is a recut of that property as two residential properties on Woodbridge, which would probably enhance the marketability of the property. And in fact, we found a builder who was willing to talk to Mr. Jambra about developing two single-family residential structures, and the builder was essentially rebuffed. So now we essentially have a mess here where we're going to get something in our neighborhood that we didn't want, a neighborhood that's been around for a long, long time. And we've got a fight on our hands. There's probably going to be litigation and other nonsense, and this wasn't necessary. Now, I sat through part of the previous meeting. I can't open a deli in Buffalo, okay, without some interface and some interaction with the Common Council. But somehow or other, without our knowledge or your knowledge, this all happened and transpired. I'm not really sure what the solution is. I think the enabling legislation is a good idea. The primary intent is to put these zombie properties back onto the market into productive use of some manner or form. It even permits the properties to be used as a public park, which would have been fine with us. But what we'd really like is two single-family residential dwellings, and the settlement agreement by which this property came into Benlick's hands is supposed to, and I quote here, to help low and moderate income families find affordable housing. Well, how did any of this help low and moderate income families?
Okay. Mr. Reese, thanks for your detailed presentation. Hold on. Do we have Mr. Mahaffey on?
No, I am Jocelyn Gordon. I'm the executive director of Benlick, our city and county land bank. So okay. I would be here to speak basically on behalf of Mr. Mahaffey, who is our board chair.
Okay, go right ahead.
Geez, I'm not quite sure even where to begin, but I'll try to be very brief and concise. Benlick is one of 25 land banks in New York State. We've essentially been in existence since approximately 2012. We've been active in Buffalo and Erie County since 2014. And we've dealt with approximately 150 properties during that time, both in the city of Buffalo and throughout Erie County. I think it's also important that our land bank is not an arm of the city of Buffalo. We are a public authority. We are a not-for-profit, and the city of Buffalo and representatives from Erie County make up our board of directors. So we are separate from the city of Buffalo. So just some brief background on that property at Main Street. Mr. Reese is totally correct. We received that property as a donation from Nation Star Mr. Cooper. As our land bank, we deal with vacancy, we deal with abandoned properties, and we try to get properties back into productive use. This property, as he mentioned, was in and out of housing court, a major nuisance property, and it was a very unique donation, an opportunity for Benlick to take in a property that's in a very strong market neighborhood, which it is, and as Mr. Reese talks about, we work typically in more difficult neighborhoods. We work and do rehabs and new construction and work with Habitat for Humanity and other not-for-profits. We work in the Delavan Grider neighborhood. We work in Riverside. We work in Lovejoy. I know Councilmember Golombek knows that we're building 2 brand new houses on Crowley Street in Riverside. So the opportunity for us to take a donation property and to sell it at its most marketable and then use that money to fulfill our mission in other neighborhoods is basically the philosophy we put in place when we received this very unique donation of a property, in the Central Park neighborhood. So that's really key, was that this doesn't happen often. We received it. We knew we would get a good amount for it, and we would put it directly to work in the neighborhoods that need the help. So that's the philosophy behind what we did with that property. And last year, when we received the property, one of the first things we did was find some commercial brokers and residential real estate brokers to walk through it with us. We walked through the property and said, what's the highest and best use? What would make this property the most marketable or desirable? And essentially the broker said a vacant lot would be the most marketable opportunity, and the property was in very distressed and abandoned condition. So right around that time, which was August, September of 2019, we started cooperating and doing some back and forth emails with the Central Park Homeowners Association, who let us know about the deed restrictions. So now we've got a green code in place that took a long time for the city to pass, and we know what the highest and best use is for that land based on the green code, and we've got deed restrictions. So instead of working with a commercial broker to market the property, we pulled back and we said, okay, we're going to sell this in-house. We put together a request for offers and sent that out to a group of brokers, also kept Councilmember Farrelletto involved and sent him a copy of the request for offers. And we included those deed restrictions right in the package along with that request for offer. So the most important thing for our board of directors with this property sale was that we sell the property with respect to, this is a strong market, the market can take care of itself. We need to respect the green code, and we need to respect the deed restrictions. Legally, you don't have to let anybody know about deed restrictions. We wanted to make sure, here are the restrictions, here's the zoning. Now bring us your offers and we'll review the offers. And the offer that was approved specifically said in his letter that he would respect the deed restrictions, that he would respect the green code, and he had the finances to purchase the property. We also kept the property on the market longer than necessary. Our board meets once a month. Mr. Giambra came to the table in November of 2019, and our board tabled the decision just to see if there were more competitive offers, who else would come in. But it wasn't our board's job to be prescriptive about the sale. The board's job was to determine that the that the buyer would respect the green code, which they said they would, and that they would respect the deed restrictions, which they said they would. And we sold the property, and we are now making use of that money in neighborhoods where we can do and fulfill our mission in a better way.
So if they don't respect the deed restrictions and those things, what is the recourse?
I don't know if that's our land bank's responsibility. But I'm open. We did sell. We sold it because the offerer and that buyer has purchased a property from our land bank in the past and did incredible job rehabbing that property, putting it back on the market and selling it. And and the track record was excellent.
I guess that's where the problem lies, is that you sold a property that had deed restrictions, but if they don't follow the deed restrictions, what's the recourse? Councilmember Scanlon?
Thank you, Mr. Chair. Just one quick question directed to you, but it's actually for Jocelyn. Jocelyn, with regards to what the chairman's saying, in the contract for sale, is that in there that they're going to meet all those restrictions?
It's in the letter of the offer package. I mean, I'm not a lawyer, so I don't want to even dip my foot. I don't want to put my foot and say the wrong thing here. Okay,
ultimately my question is there some sort of contract that exists where they're supposed to adhere to that?
I would have to defer and make sure, Mr. Scanlon.
Okay, thank you.
So right now, for Mr. Reese and that community, it's only good faith if this person who owns the property is going to adhere to the deed restrictions and those things. And so I guess that may be something that Ben Lick has to look at. How do we legislate to make certain that if that is handed off, that someone is not able to violate the restrictions, because that just would make a lot of sense. You know, if it's there because the community made sure it was there to protect their interests, and then all of a sudden you sell it and that goes away, that just doesn't seem like it makes a lot of sense. And maybe we need to have Mr. Mahaffey involved in this conversation on what things we can do to make sure that that doesn't happen. It doesn't help Mr. Reese right now, but we're hoping that the owner would be responsive to those deed restrictions, we would hope. But you're saying he's building townhouses. That doesn't seem like he's that interested in following the deed restrictions.
Yeah, I think it's important also that the buyer hasn't done anything yet.
Yeah.
Mr. Chairman,
Yes, sir. Mr. Reese.
if I may respond, their rules require a plan. This is a joke. If what's in this letter of intent here is Mr. Jambra's purchase application, the one paragraph here, it is not a plan. It is a plan to make a plan. And he made it very clear. His intent was to flip the property. He's going to double his money and run. Okay. A community, is an old joke. Who never benefits from a community benefit corporation? You know, the community or the public benefit corporation, the public. I have never seen anything this loose or sloppy in a government entity, a dealing or a contract with a government entity anywhere. And anyone who wants to call this a plan, I mean, that's just nonsense. It's not a plan. It's an acknowledgement that they have no plan. And quite frankly, what Ben Lick decided to do was take the money and run.
Yeah.
Okay, I'm sorry. What else did they do here?
Yeah. Mr. Reese, because we have our corporation counsel on, Mr. McDuffie, and see if he can add some enlightenment to what we can do with this situation. You're muted, sir.
Good afternoon, all. I have been diligently listening to the conversation. I think that in terms of the property itself, I am keenly aware of the property that Mr. Reese pointed out on Main Street, because from the housing court end, I was involved in assisting with the request for an abandonment property proceeding on that one. The tough part for us was there are properties that we know that we can go after and that we are looking to go after, but they sometimes have a nuance that puts us in a difficult place. That particular one, I think that there was a layer where there was a mortgage on it. In addition to there being a mortgage, I think that we were able to demonstrate that because there was a mortgage, the taxes and insurance were being paid. And from our standpoint, if the taxes are being paid, there's a possibility that we can't do an abandonment proceeding that's viable because it requires there being no taxes paid. It requires there being a vacancy for a certain period of time. And we were quite successful on the vacancy side, but not on the tax side. So I know to his question, how did it arrive sort of with Ms. Gordon and her team over at the land bank? I think that they diligently worked towards that, but they were able to get a push from our end and say, we have it on our radar from the Buffalo Housing Court angle. We're looking to try to find a viable way to get it from the abandoned property side, but it's very much something that we're carefully continuing to look at. To the additional question about how do we address things that are in a deed that are restrictions that are not followed. And I think that is where I see the council president has joined as well. I think that is where you may have to lawyer up and take certain things to court. There's usually two processes. Either you do things by agreement, right, which is what I talk to some of our clients about. You're in a good space by agreement because it gives you more control. But the reality is not everybody wants to play nicely with the city of Buffalo. Not everybody wants to play nicely during a project. And sometimes you find yourself in a place where you will in fact have to take certain aspects of this to a courtroom. What I will be doing, because I am not counsel to the council, I am sitting in today for your council. I'll be taking these concerns back to Kieran Gordon, and I'm sure she will take them to Corporation Counsel so that he can provide you with an official position from the department. But just on the practical side, if we can't get them to enter into some agreement that we think is important and probably binding, right? I don't think we want a verbal on this one. I think we want to be able to demonstrate that they've come before this honorable body, that they have certainly signed off in a way that they can be bound and the city can be bound. Then we may find ourselves in litigation land, and none of us want to be there, but sometimes disputes are resolved in that way. Okay, so I hope that was helpful.
Thank you, Mr. McDuffie. So, Mr. Reese, I know that doesn't answer the question, but it gives you some guidance. And if it's okay with the chairman, if you want to have some further conversation with the owner to see if you can negotiate something to work it out where it's a legal document, I would ask that you would do that, but then we can leave it in this committee and you can come back to us in a couple of weeks, or maybe if it's up to Mr. Rickalumbeck, to come back and follow up with us to see where we are with that, to make certain that hopefully we can have something going forward. I know Ms. Gordon is out ill right now, so she may not be back within 2 weeks, but at least if you can start having some preliminary conversation with the owner, maybe you can move it in that direction to get something in writing, because I agree with the counselor, we really you need something in writing. Councilmember Rickalumbeck?
Yeah, I'm fine with keeping, thank you. I'm fine with keeping this in committee so that we have a talking point and, you know, getting an answer from the law department in regards to the problem with the pact, the covenant pact that's on that property.
If I may, Mr. Chairman, Peter Reese again.
Yes, sir.
I would just like to finish by saying we didn't come, you know, looking for a fight here. And I'm not the brightest person in the world or the best connected person in the world. And yet I've found a builder who is willing to look at building 2 single-family residential dwellings here that comply with our deed restrictions. I do not understand how Benlick, which quite frankly is loaded with government officials, that's all it is, between County Executive Poloncarz and Mayor Brown, they control and they effectively own Benlick. All right, that's the board of directors. I do not understand how this happened with all of the people who are involved with this. I don't see how anybody could call that a plan. I don't understand how we didn't get some involvement of our community. And as I say, our homeowners association is still waiting for a meeting with Ms. Gordon from last year. And, you know, we haven't had it yet. There's been no response to our connection and our request. And the idea that this can happen in the city of Buffalo, where the Common Council stays on top of what is being developed neighborhood by neighborhood and district by district, is really pretty amazing. I mean, there's got to be a better way for us to do this.
Yeah, I think having this item, as the chair has said, we'll keep this item in committee, and we have some talking points to look at what we can do to fine tune this, because I agree with you. You know, if it goes to Benlick and we hand it off to someone and they don't have to abide by those agreements, then I think we're missing the boat. And I think there should be possibly some council member involvement so that we are aware of what's going on in our districts. But that's something that we have to develop as we continue to have talking points. But at least we have it with the law department. They can look at what they can do in this particular situation, and then we can go from there, okay?
Thank you.
Okay. Thank you, Mr. Gordon. Okay, motion to table. Motion to table, second by Councilmember Farrell.